Hi students, welcome back to yet another video of business regulation. Hope you are well and safe in your home. Today we are going to discuss the topic that is consideration. Consideration is very important in a contract. It is just equal to the blood of our human body. Without blood, human body cannot discharge their function. So just like without consideration, a contract is not complete. According to section 2 subsection D of the Indian Contract Act says that a consideration means quid pro quo, which means something in return. The term quid pro quo means something in return. That means it is the price paid by the promise for the obligation of the promiser. So we can say that no consideration, no contract. In other words, an agreement without consideration is void. So, consideration is equal to the price of the offer, or consideration may be service, goods or another promise. So, we can say that consideration must be sufficient and must possess some value. So, we can discuss the term consideration with an example. Here, two party is there, X and Y. X agreed to sell his TV set to Y for rupees 8,000. TV set is the consideration of Y and rupees 8,000 is the consideration of X. So in this case, both get consideration. Now we have a look on the definition of consideration. Section 2 subsection D of the Indian Contract Act defines consideration as when at the desire of the promiser, promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do or abstain from doing something, such act or abstinence or promise is called as consideration. I repeat, when at the desire of the promiser, promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do or abstain from doing something, such act or abstinence or promise is called a consideration for the promise. While analyzing this definition, we can understand that a consideration may be an act, an abstinence or a promise. An act means doing something, an abstinence means promising not to do something, or a promise. Sometimes a promise of each party is the consideration for each other. So in short, we can say that a consideration is the essential element to support a contract. In the words of Justice Patterson, consideration means something which is of some value in the eye of law. That means consideration must have some value which is supported by the law. Now we can discuss essentials and legal rules of a valid consideration. There must have some legal rules for a valid consideration. They are: it must move at the desire of the promiser. It may move from the promisee or any other person. It may be an act, an abstinence or a written promise. It may be past, present or future. It need not be adequate. It must be real and not illusory. It must be something which the promiser is not already bound to do. It must not be illegal, immoral or opposed to the public policy. So we can discuss each point in detail. So the first one is consideration must move at the desire of the promiser. In order to constitute a legal consideration, the act or abstinence forming consideration for the promise must move at the desire or request of the promiser. That means every consideration must move at the desire of the promiser, not promisee. An act done without any request is not come within the definition of the consideration. Now next is consideration may move from the promisee or any other person. Under Indian law, it is not important who has furnished the consideration. Consideration may proceed either from the promisee or any other person. Even strangers to the contract can provide consideration. So a consideration may move from the promisee or any other person. Now next is consideration may be an act, abstinence or a written promise. As I already told you that a consideration may be an act, abstinence or a written promise. Act means doing of something. abstinence means promising not to do something, and a promise. The promise of each party is the consideration for each other. So, a consideration may be an act, abstinence, or a written promise. Now, the next essentials of a valid consideration is consideration may be past, present, or future. Under Indian law, consideration may be past, present, or future. So, what is past consideration? It means when consideration by a party for a present promise was given in the past. That is, before the date of the promise, the consideration is given by the party. It is known as past consideration. In short, if the promiser had received the consideration before the date of the promise, it is known as past consideration. Now, what is present consideration? Present consideration is also known as executed consideration. If the promiser receives consideration simultaneously with his promise, it is known as present consideration. Sales is the best example of present consideration. So, this is present consideration. Now, we can discuss future consideration. It is also known as executory consideration. When the consideration on both sides is to move at the future date, it is called a future consideration. Now, next is consideration need not be adequate. Inadequacy of consideration will not invalidate a contract. So, consideration need not be approximately equal value with the promise for which it is exchanged. That means something in return need not be necessarily be an equal in value to something given. In short, we can say that inadequacy will not affect the validity of the contract. Now, next is it must be real and not illusory, which means consideration is not physically impossible, illegal, uncertain, or illusory. So, consideration must be real, competent, and have some value in the eye of law. Next is consideration must be something which the promiser is not already bound to do. That means a promise to perform a public duty by a public servant is not a consideration. In other words, when a person being already under a legal duty agreed to do something which is more than he is bound to do will be a good consideration for the promise. That means already discharged duty is not a consideration. More than that duty become the consideration for the contract. Now, next is consideration must not be illegal, immoral, or opposed to public policy. The consideration given for an agreement must not be unlawful. Where it is unlawful, the court do not allow an action on the agreement. So, these are all about legal rules of consideration. Now, we can discuss the questions which is related in this area. They are what is consideration, what is past consideration, what is present consideration. Describe the essentials of a valid consideration. So, students, hope you understand the concept what is consideration and what are the essentials of a valid consideration. So, today's session is over. We can meet in next class. Thank you.